First of all, I'm really very thankful to all of you for giving me this platform to share my ideas on, which is considered as one of the boring, but it's very, very important subject for the founding years of the, especially for the law students. So, my dear students, so today's topic is interpretation of statutes. So, I'm not taking any particular topic or any particular part of this subject. I'm going to discuss this subject as a whole. So, when we talk about the interpretation of statutes, the question arises why there is need for defining interpretation of statutes or to interpret the statutes itself, or what was the objective behind the introduction of this subject, especially for the law students. In their forming years, because it's one aspect which is the founding stone or the basic step for all the budding lawyers, or maybe some of you are going to hold different chairs in the capacity of judges or any other officers also. So it's very, very important to understand why there is need, importance, or objectives, purpose, intention behind this subject of interpretation of statutes. Before that, it's very important to understand these two terms which we are discussing or we are telling about again and again. That is, one is interpretation and another is the statutes. So when we talk about interpretation, the word interpretation, it has been derived from the Latin word interpretare, which means to explain, to expound, or to understand, or to translate the legal text. Now, the question arises, first of all, it's very important to understand of what legal text we are talking about. When we study our laws or different subjects which are being introduced in our semesters or in our yearly system, we have bare acts, and generally our teachers are after us that you should go through the bare acts, you should have a sound knowledge of the bare act language. That is the legal text. When we are talking about the interpretation of statutes, we are talking about the interpretation of those legal texts, all those legal language that has been mentioned in our bare acts, that has been mentioned in our different rules that is being laid down by our state or the central governments. And we are talking about all other such legal documents which has been passed or enacted by our governments from time to time. So when we are talking about the interpretation which is talking about understanding those legal texts, translating those legal texts, explaining those legal texts, and to have a better understanding of those legal texts. Generally, it happens when we go through our bare acts. Sometimes it happens that we may not be able to understand those legal text or the language of the bare act in a particular section, and sometimes it creates confusion also. Then we take the help of our textbooks or the reference books. Then with the help of case laws, we come to know what is the exact meaning of these words, what are those bare act provisions wanted to say in that particular section or article. And also we take help of case laws, and sometimes we see that in different case laws, those that particular section, maybe it's the same section, same subclause, has been defined differently, has been interpreted differently. So here comes the interpretation of the statute, or the importance or need of the interpretation of the statutes. How we are going to, it means interpretation is the process which tells us how we are going to translate that language that has been written in our bare acts or any other legal documents, or how we are going to apply that language in our case laws. So after that, of course, now we know when we are talking about the interpretation means we have to have the better understanding of our bare act language or any such other legal text. Now the next step, while we are talking about the interpretation of the statutes, to have a understanding of what is law, what is statute, and what is act. So generally, when we talk about the law, of course, law is a rule usually made by the government, that is state or center, so that people should or shouldn't behave in a particular way, or we sometimes we say that it is a set of rules and regulations to have peace and balance in the society, or the society should have a better rules and regulations. And when we talk about the statute, it says it is a written law that has been enacted by any legislative body. And when we are talking about this legislative bodies, it can be any federal body, state body, or maybe sometimes local bodies also. And when we are talking about the act, an act is a law that is being passed by our parliament or the state assemblies. Now the question arises, whenever we are talking about law or statute or act, the definition is somewhere same. Then what is the difference? Because it is very, very important when we are talking about the law, statutes, or the act, we should know what is the basic difference between these three terms, where we are using these three terms. So what is the difference between law and act, law and statutes, and act and statutes? It is very, very important to have a clear understanding and the different or the understanding about the differences between these concepts. So when we are talking about the law refers to the entire body of statutory, administrative, and common law provisions that regulate our society. For example, we say that India may be having more than 3,000 laws, and these laws deals with the different aspects of our life, different subject matters, different provisions. The law means the whole concept of legal system prevailing within a particular territory, prevailing within a country. And when we're talking about the statutes, we can say it is a bunch of laws. It denotes the journal form or term. For example, when we talk about the criminal laws, we may be or the criminal statutes, we may have criminal procedure code in that. We may have juvenile justice act, domestic violence act, sexual harassment at the workplaces. That is the criminal statutes. And same goes with the penal statutes, the laws or the acts where the punishment provisions has been mentioned. And then the taxing statutes, all the laws, acts, rules, and regulations relating to the taxing provisions will fall under the category of taxing statutes. So statutes means it's a bunch of laws. Means when we are talking about the criminal laws, it may further have many branches dealing with the different subject matters. And when we talk about the act, it denotes a specific form or term. For example, Hindu Marriage Act, which deals with the marriage of Hindus only. Hindu Succession Act, which deals with the succession of property among the Hindus. Same goes with the Transfer of Property Act, or Consumer Protection Act, which deals with the protection of the consumer rights only. So when we talk about the law, we can say that law is a lineage, and in that lineage, statutes are a particular family unit, and act is the parent. Lineage, when we are talking about law means the whole legal system, whole laws prevailing in a particular country. Statutes means a particular group of laws dealing with the subject matter. They may have different branches. Act means the law that is dealing with a particular subject matter. So whenever we are talking about the interpretation of statutes, we should have clear understanding whether we are interpreting the legal system, whether we are interpreting the statutes in journal, or whether we are interpreting a particular act or the particular provision of a particular act. For example, if we are analyzing our criminal laws, then we will be having the interpretation of statutes. If we are interpreting our criminal procedure code, then we are interpreting a provision of particular act. Right? So we have to keep in mind when we are talking about the interpretation of statutes, first of all, because interpretation itself means you should have clear understanding of the meanings of the words that has been used in our legal text. So whenever we are talking about the interpretation of statutes, first of all, you should have clear understanding of what we meant by interpretation and what we meant by statutes. And when we are talking about statutes, what it includes and what we can interpret. So after that, we come to the classification of statutes also. The first is the codifying statutes. When the unwritten laws are being codified our legislature, it is known as codifying statutes. Then come the consolidating statutes. When we consolidate different scattered laws in a particular way. For example, if we talk about the criminal procedure code, it lays down the procedure how the trials relating to the criminal matters will be held in our courts. So we consolidated all those statutes, and the declaratory statutes where our judicial system declare something new, or some language which has ambiguity in it, clear it and declare it. Then we talk about the remedial statutes where the judges make certain amendments or remedies on the existing statutes. Then we talk about the enabling statutes where we remove the restrictions or sometimes disability in our statutes which were hindering the meaning of the particular statutes, are known as the enabling statutes. And then disabling statutes where the restrictions on the alienation of properties are removed. Then the penal statutes where we talk about the punishment procedures. Then taxing statutes where we lay down the rules and regulations relating to the taxing system. Explanatory statutes where the words may have more than one meaning, may have ambiguities, may have vagueness, and it requires a proper explanation from the side of the judiciary. Then it is known as the explanatory statutes. Amending statutes when, keeping in mind the needs of the society, certain amendments are made in the statutes. Then the repealing statutes, which talks about when we find that we need a new addition of the words. And curative statutes, which the statutes which bring about the changes or the better words are being introduced in that particular statutes. Then we talk about the objectives of interpretation of statutes. So when we are talking about the objectives of interpretation of the statutes, we have to keep in mind there are two objectives. First is the legislative meaning, and second is the legislative intention. When we're talking about the legislative meaning of the legislative language we are talking about, so I had already discussed when we talk about the legal text, whether it's mentioned in our barracks or any other legal text that has been used in that form, sometimes it's not possible for even the persons who belonging to legal background to find out the exact meaning of those words or how we are going to apply those words. So we can understand then how tough it's going to be for a layman to understand the exact meaning of that legislative language which has been used in the legal text. So here the judiciary, because the judiciary is being considered as highest in hierarchy of the legal field, so and it's authenticated by our constitution itself, which is the sovereign law of the land or the supreme law of the land. So judiciary tried to interpret that legislative legal language in different case laws. That is the objective of interpretation of statutes, so that the laws that has been made for the betterment of the society, to deliver the justice to the society, could be understood more easily in a better way by the layman also. Another thing is the legislative intention. Sometimes it's not possible to understand the exact meaning of the legal text. Then we go by the intention behind the passing of that particular statutes. For example, if we talk about our constitution, we had introduced preamble to our constitution, and preamble, we say that preamble is, tells us about the spirit of the constitution. Preamble lays down the objectives or the intention that has been laid down in by our constitutional drafters in the constitution. Preamble says that all should have liberty, justice, fraternity, and this concept has been scattered in a different ways under different articles, so that our citizens, as well as in some because some provisions of constitution are applicable to foreigners also, so they should get justice, or they should be treated fairly, by whether it's by government or by the judiciary. So another thing, when we are talking about the objectives of interpretation of statutes, so there are two objectives behind it. First of all, to have better understanding of the legislative legal language that is being used in the different texts. Second is that to have the better understanding of legislative intention which they have while passing that particular law at a particular time. For example, initially, because when we got independence in 1947, keeping in mind the situation or the circumstances of the country at that time, because India was partitioned into two parts, India and Pakistan, and we already Britishers had adopted the policy of divide and rule. People were in poverty, illiteracy was there. So to bring about the drastic changes in the legal system also wasn't a wise step at that time. So what our political leadership did at that time, they went with the legal system that had been enforced by the Britishers, but they introduced constitution and implemented it, enforced it. And when we move to the constitution, the opening pages of the constitution starts with we the people of India are giving these provisions to ourselves. And our political leadership at that time also laid down that constitution will be considered as the supreme law of the land. And any law, whether it's passed after the making of the or coming into force of the constitution of India, or the laws were already in application, if any provision is against any provision of the constitution, it will be considered as null and void. So now we have clearly find out what is the legislative intention, that constitution is the supreme law, where the efforts has been made to give justice to each and every citizen of India. So what is the intention of the constitution, that has been laid down in the preamble of the constitution. Now if any law goes, or any provision or any subclause clause of any provision, any law, any act, any statutes goes against the provisions of the constitution, it will be considered as null and void. So while we are interpreting the statutes, or while we are interpreting our legal system or the laws or the acts, we have to keep these things in mind. First is the legislative language, whether we are able to understand it clearly, whether the legal language is not creating any ambiguity, maybe it's not behaving in injustice manner towards anyone. And the second thing that we have to keep in mind is the legislative intention. What was the intention behind passing of those acts? Whether those intentions are not against the provisions of the justice, or it's not creating ambiguity or vagueness in the society, whether it's not against any provision of the constitution. So that is the basic objectives behind the interpretation of the statute. So now the question arises, why there is need for interpretation of statutes? So first is the ambiguity. Ambiguity means sometimes the meaning of the words are not clear. Sometimes the same word may have two meanings or more than two meanings. Sometimes the same word may be used differently in the language. Sometimes when we bring about the meaning of the words, the meaning of the sentence is not clear. For example, if we take the word bank, bank may have two meanings. First, bank where we deposit our money, and second is bank is the shore of the river. So in a particular statutes, in what capacity or in what meaning the word bank has been used, that has to be cleared by the judiciary. And if it is not if our even our judicial system is not able to clear the exact meaning of the word, then there is a need to bring about the changes. Then we have to go to the intention. We have to find out with what intention that particular act or statutes has been bring into force. Another reason for which we need the interpretation of the statutes is the vagueness. For example, sometimes it happens the judiciary or our government system has to put the cap or limit, or has to define particularly what we meant, or how we are going to define that. For example, we are having two words, one is the tall and another is the poverty. So whether a person falls under the category of the poverty, that has to be determined by our government with the help of many factors. Maybe because sometimes some states are rich, some states are poor, they may it is being affected by GDP growth also, and other factor also. Maybe if in one state the person who is having 3 lakh per annum income may be considered as rich, in another state he may be considered as poor. So what is going to be the cap for poverty, that has to be decided by the government. That is the weakness of the world. Another word is tall. So if we are talking about tall, how tall? 6 feet, 7 feet, 10 feet, 11 feet, and that word tall, and it may differ from circumstances to circumstances also. So to remove this vagueness of the word, there is need for the interpretation of the statutes. And another is the drafting error. Sometimes it's possibilities, because even these laws are being drafted by the human beings only. So there are possibilities that we may have errors in our drafting also. So again, we need interpretation, or we have to interpret the statutes. Only then we will come to know whether there is any drafting error or not. Another is the inadequate words. Inadequate words, it may be due to printing errors, or it may be with the advancement of society or with the advancement of technology. For example, initially, because we don't had this internet system, but when we had this internet system, so there are more and more cyber crimes. So there was need of cyber laws. When we are having need of cyber laws and we introduce the cyber laws, of course, in our legal system we have to bring about many changes, because we weren't using those words initially. So again, there is need for the interpretation of statutes. Only then we will come to know what kind of words we are using or we need in our statutes now. Another is the new developments in words. Yes, when we introduced the cyber law, we started using new words, and for example, hacking, phishing. These words were not in our traditional legal system. So again, then when we introduce new words, and we need interpretation for those words also. Changes in the use of language over time is the another reason which led to the need for interpretation of statutes. For example, some years back we were using UK English, but now we have totally shifted towards US English, and many of our traditional English words itself has been replaced by the modern legal words. Before that, we were using more and more legal maxims in our legal system also, but now the use of legal maxim has come to an end. So change in the use of language also bring the need for interpretation of statutes. Another factor which create the need for the interpretation of statutes is the failure of legislation to cover a specific point. For example, when we have Nirbhaya gang rape case, in that case, one of the person who committed this heinous crime was under the age of 18 years. And Juvenile Justice Act says that any person who is under the age of 18 years or below the age of 18 years will be considered as juvenile and will be treated differently. But in Nirbhaya's case, the person who was at the age of 17 years has committed the crime in the most cruel manner. So in that case, judiciary interpreted the Juvenile Justice Act and taken into consideration all the circumstances and facts and come to the conclusion that, keeping in mind the circumstances, the age of juvenile may reduced from 18 to 16 years, right? So because of all this, because what where we are using legal text in our problems or the cases arising in our day to day life only. So when we are using it in our day to day life, so it means, of course, we are developing, we are having more and more scientific developments in our life, we are having technology in our life, and technology is advancing like anything. So it means that need for interpretation is the not only the need of the time at that time, but we are in dire need of interpretation of statutes in a proper way, so that the ambiguities, vagueness, any kind of errors, development in the language or technology can be introduced properly at a proper time in our statutes and legal system. So now we come to the case laws on the point. So first is the London and Northeastern Railway versus Berryman's case. It's a case of 1956. What happened in this case? Mr. Berryman was a maintenance worker in the railways. So one day he was oiling the railway tracks, and then a train came and hit Mr. Berryman, and he died on the spot. So when he died on the spot, then his wife claimed the compensation for his death. But British law was already there on the point that the person, only those persons who died while doing the relying and repairing work will get the compensation. And they went with the literal interpretation, means they went by the what the exact words being used in the statute, that it's using only relying and repairing work, and oiling the tracks is not a repairing work. So the plea of the wife of Berryman was rejected and compensation wasn't given to her. However, after some time, judiciary itself felt that rather than going with the literal interpretation of that case or the facts or the statute, we should have gone to the liberal interpretation, and then the compensation could have been granted to the wife. So another case on the point is Brock versus GPP. It's a case of 1993. So what happened in this case? The British government introduced the one law on the Dog Prohibition Act, in which it was laid down that all the dogs which fall in the types of pit bull terriers will be considered as harmful for the society. Now the question or the issue arose in the case whether the type includes breed itself. It means that only the dogs which are the breed of pit bull will be considered as harmful to the society, or any dog who is having the qualities or who is behaving like a pit bull will be considered as harmful to the society. So here the court went with the liberal interpretation and laid down that type means all breeds which behaving like pit bull will be considered as harmful to the society. So these are the two cases in which, because ultimately what is the basic purpose of law? It is so that we could give justice to the citizens of a particular country. We could work, the legal system could work for the welfare of the society. And if that basic purpose fails, then it means there is need for the changes in the ways we are interpreting our laws. That has been felt by the judiciary itself, and that's why from case to case the interpretation may differ. So another thing is interpretation and construction. These are the two words which we use in interpretation of statutes again and again. Of course, interpretation means that we go by the natural meaning of the words which are being used in our legal text, but construction says we don't go by the natural meaning of the words which are being used in any text, but we try to find out what is the intention behind those words, and then we construct the sentences which may be helpful to deliver the justice system in a better way. So now we come to the methods of interpretation. We are having three methods for the interpretation of the statutes. First is the textualism, where we go by the text that has been used in a particular document or the statute alone. Whatever is the natural meaning or the exact meaning of the words, we go by them, as we went in the Berryman's case. Another is the intentionalism. We look into the intentions of the drafters, so that there should not be any ambiguities or vagueness in the provisions, as we went in the Pitbull case. Another is the purposism, means we looks into the overall purpose for which that particular legislation was passed, and how we are going to use that purpose for which that legislation was passed to be helpful for the justice delivery system. For example, a Constitution of India, the purpose of the Constitution has been laid down in the preamble of the Constitution. So whenever we found out any difficulty, we went to the spirit of the preamble, what the preamble wants to say, because the basic purpose of the Constitution has been laid down in the preamble of the Constitution. So now we come to the rules of interpretation of statutes. Now you have to keep in mind that there is a difference between methods and rules. Methods means the tools we are using. There are only three tools that we are using for the interpretation of the statutes. Rules are those principles which has been laid down by the judicial system from time to time in different case laws, and these rules can be categorized into two categories, that is the primary rules or the secondary primary rules. And when we talk about the primary rules, it includes the rule of literal construction, mischief rule, which was laid down in Hidden's case. That's why it's also known as the Hidden's rules. Another is the rule of reasonable construction, rule of harmonious construction, and the rule of adjustum generis. And another, when we are talking about the secondary rule, first is the strict and liberal construction, and another is the maxims, which we will try to decipher with the case laws. So, first we come to the rule of literal construction. Sometimes it is also known as the grammatical rule of interpretation, or it is also known as the plain meaning rule. So, what we meant by the literal rule of interpretation means we will go with the literal, exact meaning of the words. It is a strict interpretation of the statutes. So, whatever is written in a legal text, we will go with the meaning of those words only. We will not bring about any changes in the words. We will not go with the what is the intention behind the passing of the act, because in a number of cases this rule of literal interpretation has been used by the judicial systems. So the first case on the point or on the base on this rule of literal interpretation is the municipal board versus state transport authority of Rajasthan. Now, in this case, the state bus stand was shifted from its original place to another place, and a time period of 30 days was given that if any person is having any objection on the shifting of this bus stand, they can apply for that objection. So, the applicant applied after 30 days and took the contention or the plea that the time period of 30 days should be read as the 30 days from the knowledge of the order, not with the 30 days that has been laid down by the authorities, but the 30 days time period starting from the knowledge of the applicant, or when the applicant comes to know that yes, such kind of order has been passed and he is having objection, and he filed the contention or the plea or the complaint in the to the concerned authorities. At that time period should starts from the knowledge of the order. But the Supreme Court totally rejected this plea and lay down that no, we will go with the literal interpretation of the words in the legal text in this matter, where it has been clearly mentioned that the time period will start as soon as the order has been passed by the authorities. Now here the court was right at its place also. If we go by the 30 days time period for the knowledge of the order, then every person will start filing complaints against this order after some time, that we come to knowledge on this day only, we come to knowledge on this day only. So to avoid such kind of weakness in the society, Supreme Court laid down no, the 30 days time period will be considered when the order was passed by the concerned authorities. Another case on the point is of Maqbool Hassan versus State of Bombay. In this case, a person came from some foreign country, and at the airport authorities found that he is having the gold which he hasn't declared to the concerned authorities. So he confiscated at the airport under the Sea Customs Act. So after that case was filed, or the charged, or he was charged under Section 8 of the Foreign Exchange Regulation Act of 1947. Now he went to the court and took the plea that his fundamental right that has been laid down under Article 20, Clause 2 of the Constitution, that talks about the double jeopardy, infringed here. And the court took the plea that he hasn't been charged under Sea Customs Act. No punishment was given under the act. Just gold was confiscated from him under that act, but he was being charged under the Foreign Regulations Act. He was being charged under one act only. Punishment will be given under Foreign Regulation Acts only. So there is no question of double jeopardy. He's an Double jeopardy means is and no person shall be punished for the same offense twice. So he isn't being punished for the same offense twice. He is being punished once only under one act only. So another case on the point is Manmohan Das versus Vishen Das. Again, under this act, there is a one tenant under the UP Controlled Rent Act, and under that act, it was laid down that the tenants should not bring about any changes or improvements in the building or in the place where they are living without the permission of the owner, or if there is dire need for the any additions or any improvements, then with the permission of the authorities. And they had used the word or, owner or the authorities. Now the tenants make the improvements, and when the owner objected, he took the plea that the word or has been used, so he is under the influence that yes, he can make the permission. So court lay down here that no, we will go with the literal meaning of the literal interpretation of the statutes, and the person is wrong, the tenant who has made the improvements is wrong here, because under this act it has clearly been laid down that he has to take the permission from the owner or from the concerned authorities. And another point case on the point is of state of Kerala versus Mathai Varghese. Again, in this case, a person was caught along with a counterfeit currency in the form of dollars, and he was being charged for keeping counterfeit currency. And he took the plea that that counterfeit currency wasn't rupee; it isn't Indian rupee; it is dollar, so he can't be charged. But the court laid down that in this case that we are talking about the counterfeit currency, and in the provisions nowhere it has been laid down that it should be rupees only. Counterfeit currency means counterfeit currency, and the person should be charged for that, should be punished for keeping such kind of currency with himself. So it has been laid down by the judiciary again and again in a number of cases while going with the literal interpretation of the statutes, that when we are talking about the interpretation of the statutes, first of all, the first step that judiciary has to take is to look into the exact meaning of the words. If the exact meaning of the words are applicable, or justice could be delivered with the exact or the natural meaning of the text or the statute, then the judiciary should go with it only. They shouldn't bring about the changes in the natural meaning or go beyond the natural meaning of the text or legal text or the statutes. So next we come to the mischief rule. So it is also known as Hidden's rule, because this rule originated in Hidden's case in 1584. When this case was originated, or this rule was originated in this case in 1584, it was laid down because in this case what happened, certain land relating to the religious college was given on lease to one person known as Weirs, and then Weirs sublet this land to Hiddens. After that, government passed some act because of which, or the provisions of those act, all those religious leases came to an end. So, but Weirs lease was considered as valid, and Hiddens lease was considered, sub lease was considered as void. And while declaring this law that Hiddens lease is void, the judicial system lay down certain things or certain points or certain questions or issues, that whenever we are interpreting the statutes, whether there is a mischief or not, the judiciary should go through these four issues. And those are: first is, what was the common law before the making of the act? What was the mischief for which the present statute was enacted? Secondly, what remedy did the parliament sought or had appointed to cure the disease of the commonwealth? And fourth is the true reason of the remedy. So what was laid down in the Hidden's case? Mischief means whenever there is any lacking or loophole in the legal system. So what was laid down in the Hidden's case? First of all, whenever we are passing any new act or law, we have to keep in mind, that's why we say now, whenever we are studying any law, we should go into the reasons, historical reasons why this law came into force, objectives of the law, why was the need. So what was laid down in the Hidden's case under the mischief rule, that first of all we have to keep in mind, we have to ask this question: What was the law before the coming of the new law? And what was the reason, or to remove which mischief this new statute has been enacted? जनरली वी से ना, ऐसे कौन से कारण थे जिसकी वजह से हम ये नया लॉ लेकर आए? व्हाट वर दोज मिस्टेक्स, व्हाट वर दोज रीजंस फॉर व्हिच वी ब्रिंग अबाउट दिस न्यू लॉ? For example, if we are saying that we are having cyber law right now, or the cyber law has been introduced, then what was the reasons for which cyber law was introduced? Or we can say that government during the COVID itself, government put the restrictions that we cannot forward the same messages on WhatsApp for more than 5 persons. So what was the reasons that such cap was put on? So this is the second issue we have to keep in mind whenever we are interpreting any statute. Third is the while introducing this new statute, what was the remedy that our parliament wanted to give? For example, if this cap of 5 messages only was put on WhatsApp, then what was the reasons? Because there was a Jat revolution, maximum messages were spread through the WhatsApp only, and it created havoc in the society. That's why government took the step and put this cap, so that no hatred can be spread through the WhatsApp messages. And whenever we are forwarding the messages, we find the word forwarded written over that message, so that the original source of that message could be detected easily. Another is the true reason of the remedy. Now, the remedy the legislature or the parliament wanted to give, what is the true reason for that? If we are saying that under the cyber law, punishment now, because when we are talking about our IT rules or the IT Act, now we know we are having provisions that we cannot put any kind of comments on the social apps if it spreads hatredness or it hurts someone's sentiments. So what were the true reason that this kind of remedy was introduced, or we can say this kind of text or legal text was introduced by the government? Now, what was the remedy for that? Generally, it's punishment, because we have seen many social influencers has been punished for putting wrong content on the social media apps. So what the mischief rule says that whenever the parliament is introducing any new content in the legal text, we have to keep in mind what was the reasons for the introduction of such a new text in that statute, what was the law before passing of or introduction of that statutes, what remedy our parliament wanted to introduce, or does that remedy has truly benefited the society, or it is observing that intent of justice? So case laws on the point is first is Smith's case. Now what happened in this case? In the streets of London, prostitutes used to solicit their customers in the streets itself. So the government in the London wanted to control it, wanted to have more friendly environment in the streets. So they introduced the Street Offences Act of 1959. After passing of this act, the provisions were like that if any prostitute entices any customer in the street, she will be punished. Now, what the prostitutes started doing, they started eliciting their customers through while sitting in the windows or standing at the doors. They stopped roaming in the streets. Now, the one person filed a complaint that it is an offense under the Streets Offences Act of 1959. And the prostitutes took the plea that they are not roaming in the streets, but they are enticing their customers through windows or doors only. Here, the Supreme Court didn't went with the literal interpretation. What they said that what was the mischief, or what was the that cause for which this act was passed? That was passed to have a smooth environment in the streets of the London, and to have that better environment, this act was passed. And even if the word door and the window has not been used in the act, it is clear from the intention of the legislature what they wanted to have. So the prostitutes were punished for their acts. Another case on the point is of Pyarelal versus Ramchandar. What happened in this case? This person was charged or prosecuted for selling sweetened supari, and he used to sweeten those supari with the help of preservatives, artificial preservatives. He took the plea that supari doesn't come under the food item that has been defined under the Act. But Supreme Court laid down that we cannot go with the literal interpretation of the word food. Means food means only the food we are cooking. No, no. Food means anything which is going orally or in our mouth will be considered as food item. And so the person was punished under this Act. Another case on the point is of Kanwar Singh versus Delhi administration, case of 1965. Again, in this case, Delhi Corporation Act was passed, and in which it was laid down that any kettles who were found roaming here and there will be considered as abandoned. Abandoned means they don't have any honor; they are honorless. So, under this act, many kettles were confiscated by the Delhi Municipal Corporation authorities. So, one day they also confiscated the animals of Kanwar Singh. But Kanwar Singh took the plea that the act says the abandoned animals. They are not abandoned animals, they are mine animals. They are having the honor. But the court took the plea that we can't give by the literal meaning of the words. What is the intention behind passing of this act? To have a control of the animals who are roaming here and there in the streets of different areas of Delhi. And if at any time animals are roaming here and there without honor, they will be considered as the temporary or honorless animal. So the plea of the Kanwar Singh was rejected in this case. So today we will stop here only. In the next or on the second day, means tomorrow, we will go on or move towards more technical parts, because literal means exact. We are going with the exact meaning of the words that is being used in our legal text. Mischief means if we see that the literal meaning is not able to serve the purpose, then we will go with the intention why these laws were passed or why that particular statute was came into force. What was the intention? So these are the basic rules. Next is the golden rule, and then we come to the penal statutes or the internal and external rates that will we will touch tomorrow.